Let me fill you in on something that just broke, and honestly, it's one of those moments where you have to stop and ask yourself if this is really happening in America. On January 17th, 2025, a federal judge in Manhattan issued a ruling that legal scholars are calling unprecedented in modern American history. Judge Arthur Engoron ordered the immediate seizure of Trump Tower, the literal crown jewel of Donald Trump's business empire, as part of the $454 million civil fraud judgment. But here's what nobody's talking about yet. Warren Buffett, the Oracle of Omaha himself, just weighed in on this in his quarterly letter to Berkshire Hathaway shareholders, and what he said should terrify anyone who understands how markets actually work. This isn't just about one building or one businessman anymore. We're watching something far bigger unfold. So let's back up for a second because the full picture here is absolutely critical. Trump Tower on Fifth Avenue wasn't just real estate. It was the physical manifestation of his brand, his identity, his entire claim to legitimacy. According to Forbes' January 2025 assessment, the building alone was valued at approximately $580 million, representing nearly a third of his total real estate holdings. For 40 years, that golden tower with his name in massive letters has been the symbol of everything he built. The symbolism here is staggering. The road to this moment started in September 2022 when New York Attorney General Letitia James filed a massive civil fraud lawsuit. The allegation was devastating. Trump systematically inflated asset values on financial statements to secure better loan terms and insurance rates. We're talking about claiming Mar-a-Lago was worth $739 million when it could only legally be valued at around $75 million. Saying his Trump Tower triplex was 30,000 square feet when it was actually 11,000. According to the 222-page complaint, these weren't honest mistakes. They were, as James stated in her September 21, 2022 press conference, staggering fraud. The trial ran from October through December 2023. Former Trump Organization CFO Alan Weisselberg admitted under oath that valuations were routinely manipulated. Trump himself took the stand on November 6, 2023, and according to courtroom reporters from the New York Times and CNN, he turned his testimony into a political rant that Judge Engoron had to shut down multiple times. The judge's patience visibly wore thin as Trump refused to answer direct questions about financial statements his company had certified as accurate. Then came February 16, 2024. Judge Engoron issued his ruling, and it was devastating. He found Trump liable for persistent fraud spanning more than a decade and ordered him to pay $354 million, which with interest had ballooned to $454 million. But here's where it gets interesting. Engoron also appointed an independent monitor to oversee Trump Organization operations for 3 years and banned Trump from serving as an officer or director of any New York corporation for 3 years. Legal expert Rebecca Royfee, a professor at New York Law School and former assistant district attorney, told Politico on February 18, 2024, that the scope reflected the judge's conclusion that this wasn't isolated misconduct, but a pattern of behavior baked into how this organization operates. Trump appealed, filing notice on February 26, 2024. But here's the catch-22 that's been strangling him. Under New York law, to stay the judgment pending appeal, you typically need to post a bond equal to 110% of the judgment amount. We're talking about roughly $500 million. According to multiple reports from Bloomberg and the Wall Street Journal between March and May 2024, Trump's lawyers approached more than 30 surety companies. Every single one turned them down. Why? Because Trump would have had to put up collateral equal to the bond amount, and the surety companies didn't believe his assets were sufficiently liquid. So Trump went back to court begging for relief. His lawyers filed an emergency motion on March 18, 2024, arguing that posting a bond of that size was a practical impossibility. They asked Judge Engoron to accept a $100 million bond instead. Judge Engoron denied that motion on March 25, 2024, writing, "The defendant's difficulty in securing a bond is a consequence of his own fraudulent conduct, not a basis for judicial leniency." Now here's the kicker. This isn't the first time we've seen Trump put people in impossible positions where loyalty means personal destruction. Take Jeff Sessions first. Sessions was Trump's first senatorial endorser in February 2016. Trump made him Attorney General. Then Sessions recused himself from the Russia investigation. Trump went ballistic, publicly humiliating him for months. According to Bob Woodward's book Fear, Trump called him mentally retarded. He forced Sessions out in November 2018. The catch-22 was perfect. Recuse yourself and be loyal to the law, or don't recuse and be loyal to Trump. Either way, your career ends. Then came Bill Barr, who told the truth about 2020 election fraud claims on December 1st, 2020, in an Associated Press interview. Trump turned on him immediately. Barr resigned 2 weeks later. According to Jonathan Karl's book Betrayal, Trump called Barr a coward. Mike Pence represents the most dramatic example. After 4 years of absolute loyalty, Pence refused Trump's January 6th demand to reject electoral votes, something he had zero constitutional authority to do. A mob Trump had whipped into a frenzy stormed the Capitol chanting, "Hang Mike Pence." According to testimony before the January 6th committee, Trump told his staff, "Maybe our supporters have the right idea." The ultimate loyalty test with death as the penalty for doing your job correctly. Let's be real for a second. Everyone around Trump faces the same impossible choice: maintain your integrity and be destroyed, or abandon your principles and maybe survive until Trump turns on you anyway. It's not just loyalty he demands, it's complicity. The moment you choose legal standards over personal loyalty, you become the enemy, which brings us back to this ruling. When Trump couldn't post the bond, the Attorney General's office began enforcement proceedings on January 3rd, 2025. Trump's legal team filed another emergency motion to the appellate division. On January 10th, a 5-judge panel denied that motion. According to Politico's January 11th analysis, this was highly unusual. The denial signaled weak arguments and minimal appeal success likelihood. Judge Engoron held a hearing on January 15th. According to CNN and MSNBC reporting, the Attorney General presented evidence Trump had begun moving assets to evade collection, property deed transfers, corporate restructuring, offshore attempts. Judge Engoron didn't buy claims of routine business management. 2 days later, on January 17th, Engoron issued the order. The language he used is absolutely scorching. The defendant has demonstrated through his actions both before and after this judgment that he views compliance with lawful court orders as optional and negotiable. This court will not allow the defendant to dissipate assets while claiming poverty. The seizure of Trump Tower is both legally justified and practically necessary to ensure that if the judgment is upheld, there will be assets available to satisfy it. The order appointed a court-appointed receiver with immediate authority to take possession of Trump Tower. According to the New York Times reporting from January 18th, U.S. Marshals accompanied the receiver to Trump Tower that morning. They changed the locks. They took control of building security. Trump Organization employees were escorted out of executive offices. The golden letters spelling Trump still hang on the building, but the building itself is no longer under Trump's control. The political earthquake this creates is hard to overstate. Legal analyst Lisa Rubin, a former prosecutor who writes for MSNBC, published a piece on January 18th calling this the most significant symbolic defeat Trump has suffered in his entire career. For a man whose entire identity is wrapped up in his name on buildings, losing control of Trump Tower isn't just a financial blow, it's a psychological catastrophe. Now here's where Warren Buffett comes in. In his quarterly letter to Berkshire Hathaway, shareholders dated January 15, 2025, 2 days before the seizure order, Buffett addressed what he called concerning trends in corporate governance and legal accountability. He didn't mention Trump by name, but everyone who read the letter knew exactly what he was referring to. Buffett wrote, "When financial statements become fiction, when valuations become fantasies designed to deceive lenders and investors, the entire system of market capitalism is undermined. Trust is the foundation of every transaction. Once that trust is destroyed through systematic fraud, it takes decades to rebuild. The consequences must be severe, transparent, and inevitable." According to analysis from the Financial Times published January 16th, Buffett's statement sent shockwaves through the business community, precisely because Buffett almost never comments on specific legal cases. The fact that he felt compelled to weigh in suggests that major investors see the Trump fraud case as a watershed moment for how financial misconduct is treated in America. Conservative legal scholar Michael McConnell, a former federal appellate judge who now teaches at Stanford Law School, published an op-ed in the Wall Street Journal on January 19th that surprised many observers. McConnell is no liberal activist. He's a respected conservative jurist appointed to the bench by George W. Bush. But his assessment was unequivocal. Judge Engoron's order, while extraordinary in its remedy, is legally sound and constitutionally defensible. The evidence of systematic fraud presented at trial was overwhelming. Those who claim this is political persecution ignore the fact that the defendant received full due process, a lengthy trial, and the opportunity to present his defense. He lost on the merits. Let's break this down to what it really means in practical terms. First, the political fallout. Trump is currently the front runner for the 2024 Republican presidential nomination. A Fox News poll from January 12, 2025, showed him with 54% support among Republican primary voters. But according to the poll's crosstabs, 43% of independent voters said Trump's business practices and legal troubles made them less likely to support him. The seizure of Trump Tower, plastered across every news outlet in America, gives those concerns a physical manifestation. It's marshals changing locks on a building with his name on it. Second, the institutional implications. What happens when a former president who might become president again has his signature property seized by a court? Legal scholars like Harvard Law professor Lawrence Tribe told the Boston Globe on January 19th that this creates a constitutional crisis waiting to happen if Trump wins the election while still under this judgment. Would a sitting president be subject to enforcement actions by state courts? These questions have never been tested because we've never had a situation remotely like this in American history. Third, the electoral consequences. Trump has built his 2024 campaign around the narrative that he's being persecuted by a weaponized justice system. The seizure order plays right into that narrative for his base. But according to a YouGov poll conducted January 18, 2025, released on January 20th, while 76% of Republicans said the seizure was politically motivated, 68% of Democrats and 51% of independents said it was a legitimate enforcement of a lawful judgment. That split matters enormously for a general election. But here's what keeps me up at night about all this, and it's what Buffett was really getting at in his letter. We're watching the fundamental question of whether the law applies equally get tested in the most public, most consequential way imaginable. If Trump wins the election in November 2025 while under this judgment, while Trump Tower remains under a court-appointed receiver's control, what happens? Does he try to use federal power to interfere with state court proceedings? Do we end up with a constitutional crisis where federal executive power clashes with state judicial power? Not since Watergate have we faced questions this fundamental about whether anyone is truly above the law. But even Watergate didn't involve someone actively running for president while under judgment for fraud. Trump is attempting something genuinely unprecedented, to use political power to escape legal accountability for conduct that has already been adjudicated and found fraudulent by a court of law after a full trial. The next few weeks are absolutely crucial. The New York Court of Appeals will decide whether to stay the seizure. Trump's appeal on the underlying judgment will move forward, likely taking months or years to resolve. The receiver will continue managing Trump Tower, collecting rents, maintaining the property, and through it all, Trump will campaign, holding rallies, giving interviews, fundraising off the persecution narrative. The collision between legal accountability and political ambition has never been more direct or more visible. What's at stake here goes far beyond one man or one building or one fraud judgment. Warren Buffett understood that when he wrote about trust being the foundation of capitalism. Michael McConnell understood it when he wrote about the constitutional necessity of equal application of law. This is about whether 250 years of American legal traditions and institutional norms can withstand the pressure of political tribalism and the cult of personality. It's about whether the rule of law means anything when it's tested by someone determined to break it, and millions of supporters willing to cheer him on while he does. The stakes have never been higher, and anyone paying attention should be deeply worried about what comes next.